committee he had formed to steer the funds drive, and without a cogent explanation of how the funds publicly raised for the victims had been expended. Allegation number 2, misappropriating and/or abetting misappropriation of the funds publicly raised for the victims of Londiani accident. 1. On various dates between 4th July 2023 and 9th July 2023, the Governor grossly violated the provisions of Article 10, 73, and 75 of the Constitution and Sections 29 and 34 of the Leadership and Integrity Act 2012 by A. Overseeing misappropriation of the funds raised for the victims of the horrendous Londiani Junction accident tragedy, in which over Kenya shillings 9 million of public raised funds were lost. B. Reneging on his undertaking to implement the report of the County Assembly's ad hoc committee formed to probe the misappropriation of funds meant for the victims of the accident. There is evidence that the Governor filed a suit and/or supported a suit by those implicated in the report of the County Assembly's ad hoc committee in Kericho Employment and Labor Relations Court petition number E006 of 2023, Dr. Wesley Bor and 5 others versus the Governor, Kericho County Government and others, and Kericho ELRC petition number E014 of 2023, Victor Tum and others versus the Governor, Kericho County and others. C. Being personally and directly complicit in the flawed award of direct tenders for service providers during the fundraiser and requiem mass of the victims of the accident. D. The County Governor has in this regard committed numerous and various acts in the course of his duties that are contrary to and in violation of the Constitution and the laws of Kenya. These include: 1. The authenticity of various payments made cannot be confirmed. The fact that the exact amount of money expended from the sum collected during the fundraiser points to impropriety and suggests a clear fraud on those whom the funds ought to have benefited. 2. A total of Kenya shillings 13,682,660 was collected at the fundraiser. A sum of Kenya shillings 423,000 was purportedly expended as pastor's facilitation, transport refund, field preparation, lunches and refreshments, printing, publishing, and radio announcements. Other payments that were approved from the fund were Kericho County Referral Hospital, Kenya shillings 2,037,524, Londiani Hospital, Kenya shillings 1,534,190, Supertix Limited, Kenya shillings 2,945,000, Supershine Limited, Kenya shillings 411,000, Raise Hotel, Kenya shillings 100,000, County Commissioner's Fuel, Kenya shillings 300,000. 3. That when Kenyans from all walks of life voluntarily made contributions to aid the victims of the tragedy, it was never intended or anticipated that the funds would be misappropriated with the blessings of the Governor, who had a higher calling to ensure the money is accounted for to the last coin and on whom the people bestowed their trust. 4. The Governor issued contradictory statements insofar as the use of the funds is concerned. The contradictory statements point to his being complicit in the matter. 5. While the Governor is on record indicating that the medical bills for all the victims would be waived and taken care of by the county government, it is clear why money had to be paid out from the fund collected to various public hospitals against the express and unequivocal representations of the Governor. E. By his acts of omission and commission, the Governor has grossly violated the provisions of Article 75 of the Constitution, which demands that a state officer shall, whether in private or in public, behave in a manner that avoids conflict of interest between personal interests and public or official interests, or compromises public interest in favor of personal interest. F, by overseeing the misappropriation of the funds aimed at assisting the victims of the accident, the governor violated Article 73 Sub-Article 2, which demands from him selfless service based solely on public interest, demonstrated by honesty in the execution of his duties, accountability to the public for decisions and actions, and discipline and commitment in service. G, by allowing himself to be a master of doublespeak in such a grave matter that shook the conscience of the nation, the governor violated Article 73, Sub-Article A, Roman 2 and 3 of the Constitution, which demand that he at all times demonstrates respect to the people and brings honor and dignity to the office he holds. H, by allowing himself and senior officials close to him to benefit from the funds, the governor violated Article 76, Sub-Article 2b of the Constitution, which prohibits a state officer from accepting a benefit in circumstances that compromise the integrity of the state officer. I, by failing to ensure that decision-making in the executive of the county governor are not influenced by corruption, nepotism, and other callous and improper motives, the governor has failed to exercise objectivity and impartiality, thus violating Article 73, Sub-Article 2b of the Constitution of Kenya 2010. Ground 2, abuse of office. The particulars of this ground are as follows. Allegation 1, illegal appointments, unlawful dismissals and transfers, and usurpation of the constitutional and statutory functions of county public service. The governor has variously engaged in 1, gross misconduct, and 2, gross violations of Articles 10, 73, 75, 232, 235, and 236 of the Constitution. 3, gross violations of Section 17 of the Public Officer Ethics Act, Sections 55, 59, 59A, 60, 62, 63, 64, and 65 of the County Governments Act, Section 4 of the Public Appointments County Assemblies Approval Act 2017, and variously abused his office by A, skewed, uncompetitive, and nepotic appointments of the county employees of various cadres. For instance, the governor recently hired his own brother, one Victor Mutai, as a revenue clerk. Similarly, the governor's personal assistant's wife, one Chepkirui Mercy, was recently hired as a nurse on contract basis. Who was recently hired as a nurse on contract basis was confirmed, yet there are a number of nursing staff who have been serving on contract for long without confirmation. B, illegally appointing one Mrs. Alice Bett, now Judge of the High Court, as the county attorney when there was a substantive office holder, an act which the Employment and Labor Relations Court, the Honorable Lady Justice Wasilwa, affirmed was irregular, unprocedural, and unlawful in the case of Sang versus Governor Kericho County and 2 others, petition E001 of 2023. In that case, the governor was found by the court to be in gross violation of Article 73 and 232 of the Constitution, his actions found to be illegal and unconstitutional, and ordered to pay costs of Kenya shillings 2 million and costs personally. The governor has therefore been already adjudged to be in gross violation of the law and all the Assembly and the Senate. C, causing the advertisement of the positions of doctors, nurses, early childhood education, ECDE teachers, just to endear himself politically when he knew the county government did not have capacity to hire. The applicants were subsequently not shortlisted, nor the alleged vacancies filled up. D, illegally deploying health staff via the notice dated 22nd of July 2024 without any justification, authority, and involvement of County Service Board, thus creating a crisis in the health sector. E, since his assumption of office, the governor has dismissed a total of 10 County Executive Committee CEC members, 6 chief officers, 2 chiefs of staff, among other senior staff, without any cause or reason, thus exposing the county to protracted litigation and the risk of huge compensation in damages. The governor has perpetuated this firing spree, not for any reason, but as a show of might, power, and authority, and that is where the abuse lies. Allegation 2, subversion, discrediting, and impeding of the oversight role of the County Assembly. On 3rd September 2024, the governor engaged in 1, gross misconduct, and 2, grossly violated the provisions of Articles 10, 73, 75, 174, and 185(3) of the Constitution, and abused his office by writing to the Speaker, purporting to direct the Speaker on, among other things, the timelines the Speaker should give the chief officers who are summoned by the Assembly for questioning in exercise of the Assembly's oversight mandate. Ground 3, gross misconduct. The particulars of this ground are as follows. Allegation 1, bullying, incitement, vilification of people and county staff. On various occasions, the governor has repeatedly engaged in 1, gross misconduct, and 2, gross violation of the provisions of Articles 10, 73, and 75 of the Constitution, and Sections 29 and 34 of the Leadership and Integrity Act by A, the governor has been operating with impunity as though he is above the law. On the second day of being sworn into office, the governor led a mob to invade a private land owned by one Mr. Josiah Kiplangat Kogo within Kericho town and tore down the fence. The governor has since designated the subject land as an illegal dump site operated by the county government without the consent of the registered proprietor, the National Environment Management Authority NEMA approval, gazettement by the county designating the parcel as a dump site, and in total disregard of a court order issued by the Environment and Land Court in the case of Kericho, in Kericho in ELC petition number E001 of 2022, Josiah Kiplangat Kogo versus County Government of Kericho. The governor has also obstructed the enforcement of the orders by the police administration. The actions are illegal, contemptuous to the authority and dignity of the court and the rule of law, unethical, and demeaning the office the governor holds. Further, as a result of the illegal actions of the governor, the county was condemned to pay the costs. B, none of the dismissed CECs, CEOs, and chiefs of staff and other senior county staff were given fair administrative due process and hearing, thus violating the provisions of Articles 41, 47, and 51 of the Constitution. C, the governor has persistently intimidated, molested, harassed county officers who do not sing to his tune, leaving officers jittery and creating an atmosphere of fear, uncertainty, and despondency in the county, and thus creating a toxic work environment. This violates the provisions of Sections 11 and 13 of the Leadership and Integrity Act 2012. D, the governor has persistently used divisive and unbecoming language which undermines the office he holds, contrary to Section 8 of the Leadership and Integrity Act 2012. And E, the acts of the governor enumerated above have collectively brought dishonor and disrepute into the office of the governor in violation of Chapter 6 of the Constitution and the Leadership and Integrity Act 2012. The Honorable Dr. Eric Kipkoech Mutai, how do you plead to the 3 grounds? How do you plead to ground 1? How do you plead to ground 2? How do you plead to ground 3?
Governor, you may be seated.
Thank you, Mr. Speaker, sir.
Now I'll call upon the County Assembly. So the County Assembly, you have 30 minutes to make your opening statement. Thereafter, it will be followed by the Governor's opening statement. It will also take 30 minutes.
Sorry, Mr. Speaker. Thank you so much, Mr. Speaker. Before we make the opening statement, there are certain preliminary matters that the County Assembly wished to raise. So with your permission, Mr. Speaker, I wish to be given the opportunity to raise them first.
You may proceed.
Thank you so much. Mr. Speaker, allow me to begin by raising the fairly simple and straightforward preliminary issue. By letter dated 24th August 2025 by the firm of HK Advocates on behalf of the County Assembly. Sorry, the record may not have caught my name. My name is Elisha Ongoya for the County Assembly of Kericho. And I think for members of the Senate on light note, Mr. Speaker, who may wonder whether Mr. Mutuma and I are actually on this side, we may say that the Kabrang rule has placed us this side today. Mr. Speaker knows that better than I do. By letter dated 24th August 2025, H&K Law Advocates, acting for the County Assembly of Kericho, requested the clerk of this house to make special arrangements for one witness who suffers a physical disability in the nature of mobility impairment when that time comes. So that we don't struggle at the last minute, I would wish that Mr. Speaker directs that those arrangements be made as and when that witness is required to be put on the stand.
Yeah, those arrangements are going to be made.
Thank you so much. The second preliminary issue is also relating to another letter dated 24th August 2025 and addressed the clerk of this house. Just for context, you'll notice that among the filings made by the governor in his defense was a notice of preliminary objection, which was brought to the attention of the County Assembly when the documents were being exchanged at the clerk's designated area. In the circumstances, the County Assembly wrote to this house informing it that it will be seeking the leave of this house to file a response to the notice of preliminary objection.
I think, Council, that PO hasn't been raised yet. It's on record, but it's yet to be raised.
Thank you.
So you'll be given an opportunity to make that application once that PO has actually been raised.
Thank you. Having said that, Mr. Speaker, the final is a set of documents that we also wish to be permitted to be circulated to the senators. I'll just lay a brief context for this. There are documents which, Mr. Speaker, when you are informing the senators, you drew their attention to the documents that the County Assembly brought to this House accompanying the resolution of the County Assembly. Some of those documents, unfortunately, when we are now preparing the volumes for circulation, because of the number of volumes involved, were omitted among the documents that were delivered, and other documents were also referred to the various witness affidavits, and those documents were also omitted when we were producing the volumes because of the sheer number of volumes that were being produced. If you give me permission, Mr. Speaker, I can then draw your attention to the specific documents so that then you can consider whether or not to allow them.
You may proceed.
Thank you. Mr. Speaker, you'll remember you read among the documents that the County Assembly presented to this Senate as payment vouchers for the Department of Agriculture. You also read payment vouchers for the Department of Lands and Physical Planning. Those documents, although accompanying the motion and duly presented to the Office of Speaker, were not reproduced in the volumes that have been given to the honorable senators. We beseech you to grant us leave to have those documents circulated among the senators. We also have documents that are mentioned in the various witness affidavits, but which unfortunately were not reproduced when the volumes were being made. By name, we have a staff redeployment memo dated 10th January 2025, an internal memo of the county government of Kericho. We have certain printouts of M-Pesa statements that are referred to in the affidavit of Eric Koech. We have the letter dated 21st August 2025 with regard to the report of the ad hoc committee on Kazi Mtaani, which, Mr. Speaker, you have alluded to. It is referred to in the affidavit of the motion mover. We have certain RTGS payment extracts that are referred to in the affidavit of Albert Koech. We have the termination letter of Enoch Koech that is referred to in the affidavit of Eric Koech. We have an invitation for a meeting with the Joint County Assembly Committee on Water and Sanitation and Environment and Forestry and Natural Resources and Minutes. The committee report of that committee, my apologies, the report of that committee is before this House, but only the invitation letter that was omitted in the course of the photocopying. Then we have bundles of invitation letters dated 18th July 2025 to appear before the ad hoc committee of the County Assembly of Kericho on fictitious payments. Again, the report of that committee is already before this House. So the only documents that were omitted were the invitation letters, which we seek that you permit to be presented to this House so that we have a complete record. Then finally, Mr. Speaker, we have certain photographs and an attendant certificate of electronic evidence. The photographs are referred to in the affidavit of Kiprotich Rogoni, and the certificate of electronic evidence is also in that affidavit, but unfortunately, in the course of mass production of the documents, they were omitted. Those documents, Mr. Speaker, we beseech you to allow the senators to have access to them so that we can have a comprehensive view of the situation. The other documents are the ones, as I alluded to earlier, relating to the answer to the PO. I would suspend dealing with those ones as directed by the Speaker, and I'll deal with them as and when that PO becomes a relevant issue before this House. My learned colleague should draw my attention to something so that we don't waste time. I'll ask him to just present it to the Senate right away so that the Senate can make a decision.
Thank you, Mr. Speaker, sir. For record purposes, my name is Elias Mutuma. I just wanted to confirm that the documents that my learned senior has alluded to have already been supplied to Council for the Governor through email yesterday, and physical copies were delivered this morning. Thank you.
Council for the Governor, do you have any objections to that request?
Mr. Speaker, sir, and honorable senators, we very strongly object. We very strongly object. It is true that we were Mr. Speaker, sir, we strongly object to the attempt to introduce new evidence at this point. It is true that this morning, as we were waiting to walk in here, we were served with the documents referred to by my colleague. Mr. Speaker, sir, the first point of our objection is that we will not have had an opportunity to have looked at them and to prepare ourselves to respond to them, considering that today is scheduled for hearing. The second objection, Mr. Speaker, sir, is that you already gave a timetable within which the filings were to be done, and we all struggled to file within that time, including ourselves, who had also equally voluminous documents. So the mere contention that it was voluminous is not good enough a reason. The third objection we have, Mr. Speaker, sir, is that they were not part of the documents that were used during the proceedings at the County Assembly. And for purposes of that point, Mr. Speaker, sir, I wish to make reference to your standing orders, the standing orders for this, for the Senate, particularly the standing order number 20. The standing order is to this effect. In presenting its evidence, the Assembly shall not introduce new evidence that was not part of the allegations against the governor in the County Assembly as forwarded by the Speaker. Mr. Speaker, sir, it is our contention that that standing order clearly prohibits the introduction of this new evidence. It is also our argument that if that evidence had been brought to the Assembly, there is also the possibility that the Assembly could have voted differently. And so, Mr. Speaker, sir, we take objection to the introduction of the new evidence, and we insist that the matter proceeds as per the documents that were filed within the timelines that you had given. Mr. Speaker, sir, I would like my colleague, Mr. Wanyama, to make supplementary submissions on the issue.
Mr. Speaker, sir, the honorable senators, just an additional remark. If you look at paragraph 16 of the motion and the entire motion, there is certainly evidence which the mover of the motion wanted to adduce before the County Assembly. At paragraph 16 of the motion, the mover of the motion specifically said on the floor that that evidence will be sought after asking the House to issue summons. And throughout the motion, you will see that then there is no evidence. An allegation has been made and no attaching evidence has been adduced. So that was the evidence which was submitted before the County Assembly and a decision made on them. So in accordance with your rules, and we strongly object to this, the County Assembly cannot introduce new evidence, even if it was mentioned in the pleadings before the County Assembly. It cannot introduce that new evidence before this House at this stage for only one reason. It's extremely prejudicial to the governor. And secondly, the governor has not had the opportunity to prepare on this evidence. But more importantly, this evidence requires comment from the governor. And therefore, the right to fair hearing will be severely breached if this evidence, which the County Assembly is now doing a patchwork, is introduced at this stage. And lastly, it will contravene your express, clear, and unequivocal rules that no new evidence shall be introduced on the Senate if they are not part of the evidence submitted against the governor in the County Assembly. Thank you.
Mr. Speaker, may I have a brief right of reply?
Council, let me just make a ruling on this matter. We make progress.
Thank you, Mr. Speaker.
We've had your position. We've had the governor's position. Now, if I had counsel for the County Assembly correctly, is that the evidence related to those documents is already in our bundles, the original bundles. These documents were omitted by mistake during the compiling of those bundles. they do not introduce any new evidence as is being submitted by the counsel for the governor. And therefore, pursuant to Rule 30 of the Rules of Procedure, I will allow those documents to be admitted. Counsel for the governor, you may take to the stand and make your opening statements.
Mr. Speaker, sir, we had indicated that we are raising a preliminary objection. Although, allow me to just make the observation, Mr. Speaker, sir, that much as you have made your ruling based on the premises that they were excluded, though they were part of the evidence, they were not part of the evidence, Mr. Speaker, sir. These are new documents that have never been part of this case. The nearest you could say is that they were referred to or they were alluded to in the charges, but they have never been part of the evidence. Mr. Speaker, sir, we filed a notice of intention to raise a preliminary objection, and the same was part of the filings we did within the timeline you gave us. The nature of our preliminary objection, Mr. Speaker, sir, is to contend that there was no voting that took place, and therefore it implicates the requirement, number one, that voting must have been done at the assembly, and number two, that a 2/3 threshold should have been achieved. It is our contention that the approach adopted by the Speaker in the County Assembly, the documents filed, including the audit of the logs of the process, will show that indeed there was no voting system. Mr. Speaker, sir, I pray that you allow us to raise that preliminary objection to the effect that indeed no voting took place and that 2/3 was not achieved, and therefore your jurisdiction has not been triggered as a Senate.
So, Counsel for Governor, you have 15 minutes to raise your appeal. Counsel for the County Assembly, you'll have 15 minutes to respond, and thereafter the Senate will make a determination on the matter.
Mr. Speaker, sir, the issues we raise in our preliminary objection are that we will start, first of all, Mr. Speaker, sir, we will invite your attention to the contents of an Annex 4A from the Assembly, which provides an audit of the login processes and details of how the voting went on. And Mr. Speaker, sir, that is contained in the affidavit by the IT expert at page 79 to 85, and also in the affidavit sworn by the clerk, page 95 to 93. And Mr. Speaker, sir, the IT expert says particularly at paragraph it is volume 2. Volume 2.
What is your issue, Senator for Nairobi?
Volume 2 of the County
Counsel
Assembly.
for Governor, just hold and pause the time for the Governor, please. Yes, Senator Sifuna.
No, Speaker, we've been through this process many times, and these are experienced lawyers. Part of the thing they should do before they start is to introduce to the Senate their documents. You can't just refer to documents, and we have volumes upon volumes here. I would expect that Counsel for the Governor start by telling us what his documents look like, and then we can be able to go together. Other than that, you're just speaking to yourself. With respect, Counsel.
Counsel for Governor, kindly be guided accordingly.
My apologies, Honorable Senators. I'm referring to volume 2 of the County Assembly bundle, and I will be juxtaposing that with bundle Annex 4A, also from the County Assembly bundle. Mr. Speaker, sir, our preliminary objection, the first point I wish to address is what has been referred to by the IT expert, and that testimony, his affidavit is at page 79 to page 89. And at particularly page 81, paragraph 10, 11, and 12, he indicates that they have been using certain software for purposes of payments, budgeting, meetings, and so on and so forth. Then he says in October 2024, an enactment was made of Standing Order number 77, and attendant to the enactment of that section, they then developed a system for voting by upgrading what they already had for purposes of implementation of that standing order. Then he proceeds at paragraph 23, 30, and 31 to say that system is accurate, verifiable, secure, user-specific, and friendly. And Mr. Speaker, sir, that's where our preliminary objection lies. We would like to say, first of all, if it were a specific, if it was tailored to meet the intention of that standing order number 70, the standing order number 70, standing order number 77A requires that in the event an MCA chooses not to vote, then it must be deemed to have abstained. Mr. Speaker, sir, when we look at volume 1 of the Governor's Bundle at page 98 to 101, if we could look at that. The Governor's Bundle, page 98 to 101 to 106. It is the bundle is pink in color. It will be noted that if indeed it was tailored to meet the intentions of Standing Order number 77, then it should also have complied with the detail of 77.8, which says that any MCA who has not voted should be reflected as having abstained. You will notice at page 98 that the votes reflected in that report says 33 voted and there was 0 abstain. However, when you juxtapose that, if we could go again to the volume 2 of the Assembly's bundle, you will find an affidavit by the clerk of the county assembly at page 90 to 93, and particularly at page 90, at paragraph 17 at page 93, the clerk is very specific that there were 47 MCAs in the assembly on that date. Now, our case is that the 18 MCAs did not vote at all, and we have produced those affidavits. And those affidavits of the 18 MCAs I will provide in a minute. But let me just make this first point I was making, being that if the system that they say was tailored to meet the intention of Standing Order number 77, then 77.8 requiring that it should reflect abstention, then should have reflected 18 MCAs abstained, or in the alternative, if it were to be the case which we contest, if it were to be the case that 33 voted, then it should have reflected that 14 of them abstained. And so that's our first attack on that pretense that there was any voting that happened. It is our contention that just a piece of paper was prepared. The second argument we make is that 18 MCAs did not vote, and the maximum number of votes that system should have reflected should have been 29 votes. And the affidavits that we have produced for purposes of supporting that proposition, Mr. Speaker, sir, are at page 117 to 120 of the Governor's Bundle. That is an MCA called Kiptegan. Then there is an MCA called Kibet Bozuben at page 121 to 122. Then there is Amos at page 125 to 127. Then there is Edna and Martin at page 128 to 131. Then there is an MCA whose nickname is Broker at page 132 to 134. Then there is an MCA called Gabriela at page 135 to 1. I was just struggling with the 15 minutes I was given, Honorable Senators. Then there is an affidavit sworn by one Gabriela, Honorable Gabriela at page 135 to 137, and an affidavit sworn by all the 18 jointly at page 113 to 116. In the same set of the documents, we have shown how they have already reported to the DCI for purposes of investigation of the impersonation of their votes. Mr. Speaker, sir, may I indicate that all the 18 MCAs are our witnesses, and we intend to call all of them, probably 17 or the 18. And Mr. Speaker, sir, and honorable senators, it is our contention that indeed, to the extent to which 18 of them did not vote, the representation that the 3 MCAs voted is inaccurate. It should have been only 29 MCAs. Now, Mr. Speaker, sir, we have identified particularly 4 MCAs whose signatures, whose votes were fraudulently captured as having voted in favor of the impeachment. They have said they did not vote, and to the extent to which the report on the voting at page 98 to 106 in bundle 1 of the governor's report purports that the 4 of them voted is a forgery, Mr. Speaker, sir. The other issue which I want my learned friend to highlight is that it will be noted that there are individuals, based on the login audit that the County Assembly has produced, that there were 3 MCAs who voted twice. That is Honorable Rogon Kiprotich, who is the mover of the motion. He voted twice. Not only is it reflected in the audit report, he also is on audio as telling one of the people he voted for that, please let me give you some money in exchange to you for indicating my having voted for you. The other one is Honorable Moses Rotich, who voted twice, and Honorable Beatrice Chepkoech. The other issue we wish to advance, Mr. Speaker, sir, and honorable senators, is the standing order enacted by the County Assembly itself, standing order number 77-4, which requires that when you implement the use of electronic voting, then the MCAs will be allowed, and I want to put emphasis on these 2. One is to press, not only to press, but to press a button. And Mr. Speaker, so it should be a common ground between ourselves and my learned colleagues for the County Assembly that indeed there was no gadget which could be pressed and there was no button to be pressed. What they did is to send a link to the mobile phones and ask them to enter the link and do the voting. And we are saying, Mr. Speaker, sir, to the extent to which the standing order requires that you press a button, there was no device which could satisfy the requirement for electronic voting at that point in time, Mr. Speaker, sir. 4 minutes. Okay. Mr. Speaker, sir, we would also like to point out that the entry credentials, the affidavit sworn by the IT expert multiple times at page 79 to 83, to 85, is that there was a unique criteria to enter the portal. However, it will be noted, Mr. Speaker, sir, as my learned friend will demonstrate, that the identifiers were merely the payroll number and the ID number. And so anybody who knows the payroll number and the ID number could enter and vote. And indeed, as far as we are concerned, that's what happened. And that's why we are saying that this voting system is not accurate, verifiable, nor auditable. Mr. Speaker, sir, lastly, as I hand over to my learned friend, Mr. Wanyama, is to point out, Mr. Speaker, sir, that immediately after the voting, the site was pulled down. We are meant to understand that in response to our having filed our objection, an attempt was made to set up the same link yesterday. But between the time of voting on 15th of August and yesterday and Monday, the site had been down. Mr. Speaker, sir, and honorable members, we contend that indeed this voting system does not satisfy the requirement that indeed a voting should have happened and that voting should have achieved 2/3 of the MCAs to warrant you having to entertain and determine this preliminary objection. We pray that you decline to accept this motion into your House. Mr. Speaker, sir, I request for 5 minutes for my colleague, Mr. Wanyama.
Yeah, Mr. Speaker, sir, honorable senators, there is a thorny issue which is creeping from our motion. The Kericho County Assembly has 47 MCAs. The documents submitted by the county assembly show 33 voted in favor of the motion. There are 18 MCAs before this House who say that they never voted for the motion. So outside the legalities, the Senate can determine that question factually by asking all these 18 MCAs whether they voted for the motion or not. Because Section 33, Paragraph 2 of the County Government Act, it's what gives this House the powers, the jurisdiction. So we submit that there is no proper motion before the House because of that question. It was not supported by the requisite 2/3 majority as required by the law. And why? Mr. Speaker and honorable senators, allow me to invite you to look at Volume A, Volume 4A of the County Assembly documents, because this is where the explanation comes in. Volume 4A of the County Assembly documents. Now, the County Assembly said that they used a system. They used a system which they were deploying for the first time in this voting, a system. How would an MCA access this system? You will need your IPPD number, your payroll number, and your ID number to access the system to vote. I myself, yesterday, I attempted to access this system, and I was able to access the system which they had put after pulling it down, and I was able to vote using the IPPD number and the ID number of MCS. The IPPD number is available in Volume 4A of the document. Volume 4A of the document, and allow me to just show you the yes, the same document is at volume, the governor's bundle at page 259. The governor's bundle at page 259. And then from the county assembly documents, that is page 1 of volume 4A, you will see the ID numbers of the MCS. These ID numbers were the passwords to access the system. The ID numbers were the passwords to access the system. So the ID numbers are here. They are there. Then the username is contained at page 4 of the county assembly document. Page 4 of the county assembly document, you will see the IPPD system, the unique payroll number of each MCA. So that's a system which was deployed. Now, this system fortunately leaves an audit trail. It leaves an audit trail. It's a system which, when you extract, it leaves an audit trail for you. So at page 13 of the county assembly document, their own documents which they've submitted in the House, page 13, you will see the audit trail. You will see the audit trail, whatever happened to that system, which you could access using your ID number and the IPPD number as an MCA, and anyone could access. And before I go to this audit trail, the persons who could access the system is the clerk, the MCS, and the IT personnel. So the system will tell you the whole story. So from this page 13 and from page 13 to page 14, page 13, 14, 15, you will see the audit trails. And allow me to show you this. This is very significant.
Counsel for Governor, 2 minutes.
Yes, yes. This audit trail will show that there are 3 MCAs who voted twice. And remember, this is from the County Assembly's own document. 3 MCAs voted twice. Can I show you their IPPD numbers and their names? Yes. If you look at page 16 of the volume 4A, you will see that an MCA at number 12 from the bottom, you will see the credentials of an MCA, the IPPD number, the payroll number of an MCA, which is 202-002-51726. These are the credentials based on the County Assembly document, the IPPD payroll number, the credential of an MCA known as Moses Rotich. it says yes. The logs say he voted yes. Now, hold your page on that. On the page 17, on page 17 of the County Assembly document, look at the same IPPD number. It is the same, of the same person. Same MCA, Moses Rotich. It is said he voted again, yes. So he voted twice in this system. That is page 17, the first entry on page 17. The first entry at the top there is the same entry. The same IPPD number of the MCA who is appearing on the call logs as having voted twice. That is, it appears at page 16 and page 17. Page 17, the first entry. The second MCA who voted twice is Beatrice Chepkemoi. On the 9th line, at page 16, on the 9th line, page 16, Mr. Speaker, sir, on the 9th line at page 16, you will see an MCA voting yes. And the credentials, as you can see there, the IPPD number is 202, again 202, 96089. This MCA is based on the County Assembly document. We can identify the name is Beatrice Chepkemoi, voted yes. At page 17, on the 4th line, Mr. Speaker, sir, on the 4th line, you will see the same credentials for Beatrice Chepkemoi, again voting yes, on page 17. Then the last one, Mr. Speaker, sir, with your permission, Mr. Speaker, sir, the last one, the last MCA who voted twice is the mover of the motion. The mover of the motion.
For Governor, conclude, please.
Yes, I'm concluding, Mr. Speaker, sir. The mover of the motion, Mr. Speaker, sir. He appears on page 16 of the volume 4A at line 6. And the credentials at line 6 is 202, again 202, 96039. These are the credentials of a gentleman known as Honorable Kiprotich Rogoni, the mover of the motion. And he voted yes. Now on page 17, line 7. Line 7, the same credentials of the same mover of the motion, the MCA. You can see the number. Again, it says voting yes. So that from these login trails, we have counted 36 from these reports, which the County Assembly has submitted as the evidence. There are 36 yes votes from the audit, from the login trail, 36. But as part of the demonstration of fraud, they were able to say that only 33 voted yes. But the answer is that from their own document, which they have submitted in the Senate, 36 MCS allegedly voted for this motion. And some were voting twice. Secondly, from this system audit trail, you can see there were 47 attempts to log in at that time. The major attempt was done by a gentleman known as Peter. Of course, not myself. Peter attempted to log on this system 7 times using the ID number, using the IPPD number of the MCS. You cannot see it, Mr. Speaker. You can't see the ID number because the ID number was the password. So you cannot see it. Instead, you will see the IPPD number. So you can see a gentleman known as Peter has attempted to log in 7 times. And the login trail will indicate that there were 47 successful login attempts. And then, this is maybe the second last point as I sit down. The technical people, while this system was running for voting, the technical people accessed this system 2 times. And allow me to just point out the last one at page 17 down there. At page 17, the second last entry on page 17, you will see log user admin. It's the same log user, then accessing the system again at the end of it. And then at page 15, because this is in the middle of voting, at page 15, line 4, you will see the admin accessing the system. So our point is that, and then if you do, Mr. Speaker, if I have time, I will tell you, I'll actually show you that there are some MCAs who, or not really MCAs, persons who were able to access the system because the voting duration was between 14 and 45 seconds. You log in, it shows that you have logged in, then you log out for between 14 and 45 seconds. But there are some persons who access the system for more than 2 minutes. They just logged in and then they were there throughout. We're wondering what they were doing in the system. And then lastly, there are persons, if you look at page 13, when the voting is now about to come to an end, at entry number 7, you will see an MCA who had voted, but then accessed the system. You can see a login attempt. They have accessed the system. And then they never left the system. So the question that we are asking is really peremptory as I wind up my submissions on this inquiry. Is this system secure? Is this system based on this evidence accurate? We have an affidavit of an MCA who said that someone else voted for him. If I, as an advocate, can access the system and vote, so what about persons who have knowledge to the system, including the user developers? They say this system was developed by the IT department internally. And remember, it was being used for the first time by the county assembly on a very serious matter which has heavy constitutional implication. That is the impeachment of a governor. So we are asking, is this system accurate? Is it verifiable? So in our submissions, and we conclude this by saying, because we have laid basis of fraud, a fraudulent pattern by the persons who are in charge of this system, and because the 17, 18 MCAs are here, this Senate, being a house of record, has an ultimate responsibility to inquire on that question now as part of the preliminary inquiries and vote on it. Ask all these MCAs. Mr. Speaker, sir, if you remove
your
47,
time is up, Counsel for Governor.
Thank you.
You are repeating yourself, basically.
Thank you, Mr. Speaker, sir. I will sit down.
Counsel for the County Assembly.
Mr. Speaker, can I be heard? Mr. Speaker, can I be heard? Thank you. Mr. Speaker, my name is Elisha Ongoya. I beg to reply. For starters, in response to this notice of preliminary objection, the County Assembly has filed grounds of opposition named Volume 7. It's a small volume. If it has gone round, it has gone round just a short while ago. And an affidavit named Volume 7A, being the affidavit of Edna Chepkirui Tonui. I begin by begging, Mr. Speaker, that these documents be deemed to be validly on record. They are the documents I alluded to earlier. Having said that, I begin by saying that if you look at the written notice of preliminary objection, there are two elements of the objection that my learned colleagues for the governor have either abandoned or not alluded to specifically, alleging violation of a court order and reintroduction of the motion, because they have not argued it.
Counsel for the County Assembly, respond to the PO. Not the proposed PO.
Thank you so much, Mr. Speaker. I'm comfortable with that. I'm comfortable with that. Thank you so much, Mr. Speaker. Having said that, allow me then to start with the issue that Mr. Wanyama, learned counsel, raised here by saying he personally logged into this system and voted. That qualifies him to be a witness who needs then to demonstrate to this House how he logged into this system and how he voted, and therefore be a proper subject of cross-examination. Anything short of that, Mr. Speaker, distinguished senators, is nothing more than mere sensationalism, and I beseech you to treat it as such. The second issue, Mr. Speaker, is on the allegation of the logs that you have just been taken through. And I wish to present just 1 minute. it's amazing how sensationalism can arise. But if you go to page number 13 of volume 4A of the County Assembly's documents, the audit logs run from page 13 all the way to page 17. And allow me to demonstrate why you cannot determine this objection on the grounds raised by my learned colleague, Mr. Wanyama, by referring to a decision of the High Court on a similar issue. This Senate impeached another governor called Governor Mike Sonko Mbuvi Gideon Kioko, and an issue of electronic voting arose in that matter. When that matter went into the High Court, there was a petition number A425 of 2020 that was considered by the High Court, and the judgment is publicly available on the National Council for Law Reporting. At paragraph 169 and 170 of that judgment, the three-judge bench of the High Court observed, and I quote, "The court is now left with two separate sets of affidavits that present contradictory positions. On the one hand, some MCS aver that their login credentials were forged. Same thing you are hearing here, and that they never participated in the voting process on 3rd December 2020, and even went to the extent of making a report at Kwale Police Station. Same argument you will hear here. On the other hand, 20 of the same 39 MCS swore affidavits for the governor. 20 of them swore fresh affidavits on 4th December 2020, stating that they willingly voted on 3rd December 2020. You will find the same scenario in this case before you. Same scenario. The Hansard, this is the High Court saying, which is the official record of the County Assembly, shows that 90 MCS voted in respect to Honorable Ogada's motion. In view of the contradictory averments by some of the MCS who are alleged to have been in Kwale, coupled with the lack of any expert evidence in support of the alleged hacking. Let me stop there by demonstrating that Mr. Wanyama is a lawyer like me. He's no expert in ICT. He will not guide you on the functionality of ICT. Coupled with lack of evidence to support the alleged hacking, we find the petitioners did not establish that the 2/3 statutory requirement for the impeachment of the governor was not met. Having said that, let me go to the logs at page 13 to page 17. These are logs in a system, in an ICT system, and yet what you have before you is a printout of those logs. It means one must copy the logs, then print them out. That's the only way we can present the evidence of the logs here. Otherwise, this ICT expert has put the link in his affidavit, and when he takes the witness stand, when the trial starts, he will demonstrate to you how this system works, and you will see the logs themselves. But to give you a printout, which is a requirement of the rules of procedure, one has to copy the logs and put them here. And therefore, if the logs are copied twice, it does not mean that somebody voted twice. Allow me to take you through the exact entries that my learned colleague, Mr. Wanyama, has alluded to. At page 16 is a log called at 15th of August 2025 at 19:25:29 hours, 7:15 p.m. and 29 seconds. He alleges that there is a vote cast by that IPPD number. And you go to page 17, you see where he's alluding to at the first line, 15th August 2025 at 9:15:29, vote cast by that IPPD number. Let's look at the next log. The next log 15 August 2015, 1915, 26. Let's go to the corresponding log on the following page, 17. 15th August 2025, 19, 15, 20, 26. The same hour, the same minute, the same second. Go to the third entry, senators. This is 19, 15, 23. Then you got the following log, 19, 15, 23. Failed log. You see the same entries of the same IPPD number by the same person at the same hour, same minute, same second. This is a product of the copying of the logs for purposes of printing. It is not the logs in the system. It's how when you copy the log to print, you can copy twice. The results of this election, which my learned course will notify, are at pages 21 to page 26 of volume 4A. My apologies, not 26, 28. The results are at pages 21 to page 28. And if you go to page 22, at the second box from the bottom, that is Honorable Chepkemoi Beatrice, you notice she voted yes at 19, 15, 19, and you don't see her in any other entry in the results of the vote. These are the results of the vote. This is what the speaker declared. You run from page 21 to page 28. You will see every senator, sorry, my apologies, every MCA who voted yes captured once. I juxtapose this data, and possibly, Mr. Speaker, when the members will be contributing, fortunately for us, this Senate is a crucible of talent. There are multiplicity of talent here, and there are ICT experts among you. They will demonstrate very clearly that you can't take a copying of the logs to print when it's copied twice, say therefore somebody voted twice. Otherwise, it will mean that these people were so meticulous that from that entry that Mr. Wanyama began with, up to the second last entry on that page, and when you go to page 17, from the first entry up to 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, up to the 11th entry, those people transacted meticulously at the same time, second, minute, hour. It makes no sense. That's number one. Number two, in their submissions, my learned colleagues have said they will call witnesses to prove these facts. It means what they have raised before you are questions about credibility of witnesses. The forum for testing credibility of witnesses is in the trial itself, so that this ICT expert will take the stand, take you through the procedure, take you through these logs and field questions, and then you'll be able to test the credibility. And that will be the case for any other person, including members of the county assembly. I'm making out a case that what has been argued before you is not a preliminary objection by any stretch of imagination of that word preliminary objection. These are contentious, convoluted matters of law, which even you have seen. My learned colleague, Mr. Wanyama, wishes to convert himself into a witness and also tell you how he participated in this voting process himself. We have no problem with that, senators. If my learned colleague, Mr. Wanyama, wishes to take the witness stand and adduce that evidence, we have been here long enough to demonstrate that we deal with that in cross-examination. It is the only tool known to law for testing veracity of evidence. Allow me then to go to the standing orders. Standing order number 77 of the Kericho County Assembly standing orders is the operating standing order for this process. I will also briefly allude to standing order number 83. Standing order number 77 provides that unless the Speaker, for the convenience of the Assembly otherwise directs, voting on a division in the Assembly shall be by electronic voting, so that The first grievance that my learned colleagues for the governor are raising is, why did the speaker comply with standing order number 77? That's the essence of the objection. 77.3 provides that during electronic voting, members shall cast their votes by pressing either the yes, no, or abstain button. I sat here and I listened to my learned colleague, Mr. Katwa Kigen, most polite colleague that I know, very courteous colleague that I know, saying that the word button means a manual button. A manual button. Technology has evolved. And when an electronic system prompts you with the 3 electronic buttons, yes, and you press it, no, and you press it, abstain, and you press it, I respectfully submit, you have pressed a button. So partly, again, this objection was based on a very manual understanding of the word button. And I don't know how much more I can say about that, but I think, Mr. Speaker, Senators, that's the best I can do. To say that because Kericho County Assembly has technologically advanced, that people can press electronic buttons as we do with our M-Pesa smartphones, we admit yes or no or cancel without pressing a manual button, or as we do in our ATM machines. The ATM machine prompts you. You select bank statement, select withdrawal, select electronically on the screen. To say that because Kericho County Assembly is at pace with that technology, we must therefore fault it. It will be a sad day in the history of governance of this country if we reached that verdict. So, Senators, you have been told that certain MCAs have sworn affidavits distancing themselves from the vote. We have demonstrated that this is not a new game in town. Number one, in the Mike Mbuvi Sonko case, that happened. The court determined the Hansard is the authoritative source of information. The only way to counter that is when those witnesses come here in the trial itself and their evidence is tested. But number two, when you finally look at volume 7A, this is an affidavit of one of the said 18 MCAs denying swearing those affidavits that the governor has brought before you. One of them sworn an affidavit is here before you. Distinguished Senators, can we resolve this matter without putting the actual people on the stand at the trial to resolve that matter? I submit respectfully that's impossible. Mr. Speaker, I know my time is up. May I just get 2 minutes to sum up my argument? Mr. Speaker, my apology, my time is up. I want to just get some 2 minutes to sum up the argument.
2 minutes.
Thank you so much, Mr. Speaker. So, Mr. Speaker, what are we saying in a nutshell? In a nutshell, we are saying that there is a witness affidavit supported by documents running from page 1 of volume 4A, running from page 4 of volume 4A to page 44 of volume 4A, giving you an audit trail of this voting process. Nothing can be a clearer explanation of a verifiable and accountable system of voting than a system that generates this kind of audit trails. So you can't fault a system that can generate this volume of audit trails and say it is faulty. Number two, you have been told that these MCAs are not technologically advanced and could not vote. Pages 1 to page 3 of that volume 4A is evidence of Kericho County Assembly buying for these MCAs laptops to technologically enable them way back in September 2024. Way back in September 2024, and therefore the Assembly has done its part. What is the correct approach to this objection, Mr. Speaker? I suggest that, Mr. Speaker, the matters raised in this objection be subsumed in the trial. These matters be tested through the trial, and these matters be determined as part and parcel of the questions of fact and law that this Senate shall deal with at the voting stage of this motion. I respect Mr. Speaker, and I rest the County Assembly's case.
Counsel for the Governor. Now, Honorable Senators, pursuant to Standing Order 34-2A, I will allow not more than 15 minutes from 1 p.m. to enable the Counsel for the Governor to respond to what has just been submitted to by the team from the County Assembly. You may proceed. You have not more than 15 minutes because the House must rise at exactly 1:15. You need not take the entire 15 minutes. You may proceed.
Mr. Speaker, sir, the first point we wish to observe is that in response to our preliminary objection, one of the issues we raised in our preliminary objection is that the entry credentials, being the use of an ID number as a password and use of payroll number as username, has not been contested. And the emphasis in it is that those two particulars are publicly available. Anybody who works with the county can easily access the ID number and the payroll number, and therefore it should have been possible. Indeed, it happened that other people intercepted the system. And these buttresses the arguments made by my learned friend, Mr. Wanyama. When he pointed out somebody called Peter and others who logged in, including the admin who in the audit report is indicated as having entered, whilst it is the clerk who is said to be the admin of the system. The second argument, Mr. Speaker, sir, I know my learned friend, my learned friend for the County Assembly has tried to belittle the point we are making about the issue of the button and pressing. And Mr. Speaker, sir, and honorable senators, if it was intended that you can use electronic means and not necessarily a device that is secure, then even the Senate would have otherwise had to use a different system. It would have, in place of requiring, first of all, you will recall that the enactment of that Standing Order number 77 was made in October 2024. It is hardly a year ago. And so if the Kericho County intended to be very electronically advanced, then they should have, in place of using the word button, said we will use a link to vote. If it was intended that they should not necessarily press but click to vote, then they should have used the word in that Standing Order number 77.3 to say we will vote by clicking, not press. Mr. Speaker, sir, I insist that the intention of Standing Order number 77.3 was to ensure that there is an accountable, responsible, and verifiable voting system. Mr. Speaker, sir, my learned friend, in response to the arguments we've made in respect to Standing Order number 77, has invited your attention to Standing Order number 80. And he puts emphasis on the prerogative that the Speaker has in allowing the use of electronic voting. In reaction to his invite to you to make reference to Standing Order number 80, we would like to invite you to the Standing Order that is immediate before the one he has referred to, Standing Order number 80, being Standing Order number 79, which says that if MCS insist that they want to vote by roll call, then the Speaker has no choice, provided there is somebody who has objected and is supported by more than 5 people, is supported by up to 5 people. In this case, Mr. Speaker, sir, we have invited your attention to the fact that there were 18 people who are opposed to this style of voting and wanted a roll call voting. For that reason, Mr. Speaker, sir, it is our argument that the only reason why the Speaker defied the provisions of Standing Order number 79 is because there was intention to fraudulently misrepresent the votes that were cast by the MCS. Lastly, Mr. Speaker, sir, as I hand over to my learned friend, Mr. Wanyama, it is said that this system was secure. And that point is buttressed by the affidavit by the IT expert that my learned friend, Mr. Ongoya, has repeatedly made reference to. And one of the things then that come up for your consideration in our preliminary objection is this. Can we determine for a fact that the 4 MCAs who say they didn't vote indeed voted? And Honorable Senators and Mr. Speaker, sir, it is my submission that the only way we can determine that is to determine whether the link was sent to that respective MCA and that MCA specifically voted using his number that the link was sent to. And Mr. Speaker, sir, you will see from the audit logs that the audit log does not indicate anywhere the numbers to which the link was sent, nor the IP address of the devices that were sent. And therefore, it goes into the question of the scheme to manipulate these votes. The inverse of that, and the only way that the county could possibly say that they have an absolute answer to the question of whether or not the votes were manipulated, is if they could demonstrate that indeed the link was sent to an individual and that the IP address of that phone gadget was the one that cast those votes. Mr. Speaker, sir, to the extent that the audit report brought to you avoids by design to give you that information, Mr. Speaker, sir, we say creates a doubt in your mind. In closing my part of my submission as I hand over to my learned friend, Mr. Speaker, sir, this is our argument, that indeed there was no voting, and therefore the threshold of 2/3 was not achieved. But as a rider to that argument, Mr. Speaker, sir, and the honorable senators, it is our argument that even if, as my learned friend says, there is a possibility that this system was okay, if there is doubt in your minds that indeed this system might not have been foolproof, if there is doubt, that is enough reason for you to decline entertaining and determining this motion. For all those reasons, Mr. Speaker, sir, and honorable senators, we pray that you reject this motion on the basis that you are not satisfied that indeed there was a motion that was properly considered, that it was properly voted for, and that the purport that there were 33 MCAs supporting the motion has been achieved. That's all, Mr. Speaker, sir.
Yeah, Mr. Speaker, sir, I will stick to the time. Just in quick rebuttal, I would like to invite the honorable senators to look at the governor's response at page 113. My colleague, Mr. Ngoya, talked about one MCA. That's the governor's response, page 113. The governor's response, volume 1, at page 113. The governor's response, volume 1, at page 113, because ultimately for the Senate to determine that the motion is properly before it, it must be satisfied on the threshold. From the 47 MCAs in the county assembly, at least the threshold requires that 32 of them vote in favor of the impeachment motion. Now, at page 113, it is true what Mr. Ongoya has said, that one MCA has sworn an affidavit. Principally, they jumped ship, swore an affidavit saying that they didn't meant what they said. But there are 17 other MCAs who have evidence in support of the PO at page 113. 17 MCAs. Ultimately, this is a process that follows the law. The Constitution is the Senate is a house of record, house that follows the Constitution, follows the law and the standing orders, and looks and listens to the evidence. So what is the evidence that I am showing you here? At page 115 is the evidence of 17 MCAs who have said they never supported the motion. So what does it mean? Do we have contrary evidence to rebut the cogent allegations by these 17 MCAs? If you do a quick calculation, minus 47 minus the 17 from 47. How many numbers do we have? We have 30. Does 30 meet the threshold in section 33(2) of the County Government Act? The answer is definitely not. Do we need to wait for this question to be subjected to trial the way Mr. Ongoya has invited? The answer is no. The evidence is before the Senate to determine the issue. What about the logs? We are relying on the logs given to us by the county assembly. They are the ones with access to the system. They printed it out and submitted to the Senate. We are simply relying on it, and we have pointed out more than 10 mistakes on the logs. Why can't they just do impeachment on the right thing? Why are they hiding in technology, trying to manipulate the votes for purposes of achieving an objective which the Constitution requires a very high threshold? Just to finish, Mr. Speaker, sir, we have also audio evidence, KB1, which we request that when you retire, you can have opportunity to look at it. That is KB1. It just fortifies it fortifies this fundamental point that we have a problem on this matter that is before the Senate at the threshold question. One of my colleagues, Mr. Speaker, sir, asking if we can play the audio. We have time for the audio. With your permission, can we play it?
Proceed. You have 2 minutes to do that. The Senate will rise at exactly 1:15.
Yes, we are requesting that KB1 be played. Sorry.
Mr. Speaker, subject to your guidance, I'm just wondering whether introduction of new evidence in this matter, I'll be able to respond to it, because that's now new evidence.
It is part of the bundle. Yes. It's part of the evidence that is already on record.
Because we can't comment on it once they have played it, but we could have commented on it, Mr. Speaker. If they had played it earlier, then we can comment in our response.
Just proceed and play the video.
Yes, Mr. Speaker, sir, we request for the KB1 to be played by the ICT staff.
We urge more counties to do their own ERP system just the way we have been doing. It is something that has made the county work efficiently in terms of their elections.
Don't waste time. You're giving the out of the country, Wendy.
Your Honor, the screens, Mr. Speaker said the screens are off. There was a transcript. Yeah.
Don't waste time. You're giving the out of the country, Wendy. Is ready. Ona mwanachi, mamaja wa itu tune, yangi male posters, iza merawe, azana nkoro. Kifutani enyina bread, sign affidavit ko, rone agi bet. In fact, oda muja dengone 200,000, agi yogabuza.
Oja wakso.
Imagine anaiwendi.
Jawa kaki mutambi that agi biru baga Dubai. Bari ki wolo for ina mugi mo.
Dubai muti we mache gani ma muje cho.
Ami resap kabisa mi aglo kyukwe.
Mache ngero yawe. Na ge ma cho. Wale si. Ikaza ngibe. Na mora. Oya jabru kura otiana.
Go biru angure?
I'm using it because of you.
But who ran you? Yeah?
I don't go in to governors.
Deny
it.
Yeah? Yeah. Come on, Rurun. Yeah, thank you, bro. Come on, Lini.
Do it. You are defending and governor, the give Sarta. Cha.
Are isn't it the other?
Yeah, Jawi, we have that. I don't believe it. I never lived in the
Time is up.
Yes, Mr. Speaker, sir.
I'm
Thank you.
afraid
Thank you very
cannot
much.
transact beyond 1:15.
Thank you very much, Mr. Speaker, sir.
Now, Honorable Senate, just take a seat, take a seat, take a seat. I will deliver my ruling at exactly 2:30 today on the matters that have been raised. Senate, arise. Honorable Senators, it is now 1:15 p.m. time to adjourn the Senate. The Senate therefore stands adjourned until today, Wednesday, 27th of August, 2025 at 2:30 p.m. Sisi watumishi wako ambao umeridhika kutuita kwa nyadhifa za uongozi katika jamhuri hii yetu, tutakuomba utuajalie tuyatende na kufikia mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Sergeant at Arms, kindly ring the quorum bell for 10 minutes.
Good morning. If you are just joining us, these are live pictures from the Senate chambers. There is a slight quorum hitch, and the Speaker ordered the quorum bell to be rung so that the respective leadership in the House can mobilize the senators to come take their seats so that the business of the Senate can begin. This morning, the senators will be considering the impeachment of Kericho Governor Honorable Eric Mutai, and there will be a closed session, that is the pre-hearing meeting for the senators. It's supposed to last 1 hour, and thereafter the session will be back on air for the preliminaries, where there will be recital of the mandate of the Senate, rules of procedure, and hearing program. There will also be the introduction of members of the County Assembly of Kericho, representing the County Assembly and their council, if any, and there will also be the introduction of Governor of Kericho and the council representing the governor, if any. Thereafter, the charges will be read, and it will be followed by preliminary questions or issues, and later the Senate will take a break and will resume, where there will be the opening statement on behalf of the County Assembly. There is an allocation of time, 30 minutes, followed by the opening statement on behalf of the governor. Also, the time allocated here is 30 minutes. It will be followed by evidence by the council or the County Assembly, and this is evidence of witnesses, if any, cross-examination and re-examination, and this has been allocated a total of 5 hours. The County Assembly, maximum of 3 hours for evidence by witness and re-examination, if any. The governor, maximum of 2 hours for cross-examination, and thereafter the Senate will adjourn. The special sitting is scheduled to take place today, tomorrow, and Friday. The business of the Senate is considering the impeachment of Governor Eric Mutai, the governor of Kericho County, who was impeached by the County Assembly, and his impeachment was brought to the Senate for hearing. Any moment now, the business of the Senate will commence, and this is not the first time that the senators are engaging in this kind of business. It is the mandate of the Senate to hear the impeachment of governors, and it has done so over the years. So this morning, all the way to the evening, tomorrow and on Friday, the senators will be considering the dispute that is arising from the impeachment of the Kericho County governor. And just a quick recap of the order of business this morning. There will be the pre-hearing meeting for senators. This will last 1 hour. It is a closed session. It will be followed by preliminaries, where there will be recital of the mandate of the Senate, the rules of procedure, and the hearing program. After the hearing program, there will be introduction of members of the County Assembly of Kericho representing the County Assembly and the council, if any. There will also be the introduction of the governor of Kericho County and the council representing the governor, if any. And thereafter, the charges will be read. This will take approximately 30 minutes. And after that, there will be preliminary questions or issues. And after that, the Senate will take a break. And when it resumes at 2:30, there will be the opening statement on behalf of the County Assembly. The time allocation here is 30 minutes, followed by the opening statement on behalf of the governor. Also, time allocated there is 30 minutes. Thereafter, there will be evidence by the County Assembly, evidence of witnesses, if any, cross-examination and re-examination. The time allocated for this exercise is 5 hours. It includes the County Assembly, maximum of 3 hours for evidence by witness and re-examination, if any, and the governor, maximum of 2 hours for cross-examination. After that, the Senate will adjourn and resume the sittings tomorrow. If you're just joining us, these are live pictures from the Senate. The quorum is yet to be achieved, and as soon as the quorum is achieved, you'll be able to follow the proceedings live on KBC Channel 1 and on YouTube, courtesy of the Parliament of Kenya YouTube channel. The procedure for removal of a governor is contained in the standing orders of the Senate, which says that within 7 days after receiving notice of a resolution from the Speaker of a County Assembly supporting the removal of a governor of the county pursuant to Article 181 of the Constitution, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the governor, and the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter, or investigate the matter in plenary. In this case, the case against the governor will be considered or investigated in plenary. The Senate sitting in plenary or the special committee appointed under subsection 1 shall within 10 days investigate the matter, and in the case of the special committee, report to the Senate on whether it finds the particulars of the allegations against the governor to have been substantiated. The governor shall have the right to appear and be represented before the Senate or a special committee during the investigations. If the special committee reports that the particulars of any allegation against the governor have not been substantiated, no further action shall be taken under this section in respect of that allegation, or if the special committee reports that the particulars of any allegation against the governor have been substantiated, the Senate shall, after according the governor.
Order, honorable senators, we do have quorum now, so let's get down with today's business. Clerk, you may call the first order.
Order number 1, communication from the chair.
Now, honorable senators, I have a communication to make relating to the business of the Senate, scheduled for consideration during this solemn sitting. You will recall that at the special sitting of the Senate, held on Wednesday, the 20th of August, 2025, I appointed today, Wednesday, 27th of August, 2025, Thursday, 28th of August, 2025, and Friday, 29th of August, 2025, as the days when the Senate will hear the charges for the proposed removal from office by impeachment of Honorable Eric Mutai, the Governor of Kericho County. Now, via the Gazette Notice number 11-796, dated the 21st of August 2025, I notify the general public that pursuant to Standing Order 81B2 of the Senate Standing Orders, the Senate shall investigate the proposed removal from office by impeachment of Honorable Eric Mutai, the Governor of Kericho County, in plenary. Consequently, a hearing program has been prepared and appended to the order paper for today. Now, honorable senators, ladies and gentlemen, in accordance with the schedule of activities for an impeachment hearing in plenary, the Senate will hold a closed-door preparatory session to deliberate on the management of the investigation. The objective of the preparatory session is to ensure that the process is conducted seamlessly, concluded timely, and in line with the requirements set out under the Constitution, the County Governments Act, and the Senate Standing Orders. Now, honorable senators, during the pre-hearing, the parties, if they are present, all members of the public and the media will be expected to withdraw from the chamber, and the galleries and any form of broadcasting from the chamber shall cease forthwith. Consequently, I now direct the parties, all members of the public, and the media to withdraw from the chamber and the galleries, and that any form of broadcast from the chamber to cease forthwith. In accordance with the hearing program for an impeachment hearing and plenary, the open session will commence at 10 a.m. I thank you.
Call to the performance of important trusts in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the peace, prosperity, and welfare of our country and of those whose interest you have committed to our charge. Amen. Sergeant at Arms, ring the quorum bell for 10 minutes.